Welcome to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BPI Law Group. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please don't ask your questions. If you're an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact attorneys directly. We will be also taking any general immigration questions along with today's topic. Hello Bhanu Garu, welcome to the show.
Thank you, Torani. Thank you for welcoming me on the show.
Yeah, hope you're doing well, sir.
Yeah, I'm doing good, thank you.
Right, so today's topic is latest immigration updates, and this is a continuation to the last week's topic. We will continue the knowledge session this week along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and ask for tips. So, Bhanu Garu, starting off, do we have any updates on immigration this week?
Not really many updates, as we all know that right now everyone is busy with the H-1B cap registration for the fiscal year 2023, and the registration is going to end on the noon of March 18, 2023. That's only the update I would like to speak with. Another update I would like to speak with is the EB-5 program. Okay, we know that for the EB-5 investor visa, there was something called Regional Center Program, and the program was sunset long time ago. So many people who actually invested in the commercial entity through the Regional Center Program and hoping to get their green card as an investor in the United States, those green cards were held in abeyance because the Regional Center Program has been sunset. The Congress has to reauthorize that program, and fortunately, there was a very good bill was introduced in the House and in the Senate, and it's likely that this bill may be authorized, and accordingly, they may reauthorize it so that all these people who are in line waiting to get their green cards through investor visa may be able to get their green cards eventually, because they will be able to adjudicate their immigrant visa petitions, that is Form I-526 that is submitted through the regional center programs for the USCIS to show that they qualify for the investor visa. So that is very good news. We hope that that bill will pass and the Congress reauthorizes the regional center program, and then that program will be valid through 2027, and hopefully it will continue beyond without lapsing like how it has been happened for past 1.5 years right now. That is only the update which I would like to speak with, and the bill is very promising. One more thing in that bill is that maybe they will increase the limits of the regional center investment from 500,000 to 800,000, and also the other non-metro, non-regional center or non-targeted employment area investments to $1,250,000, $1,250,000, something like that. I don't remember the exact number, but something like that. But but it's going to increase as well along with this thing. And third thing is the targeted employment areas will be designated by the USCIS, by the Department of Homeland Security, for the investor visa purposes. Right now, Department of Commerce in each and every particular state actually designates or authorizes or notifies which area qualifies as a targeted employment area. That is something which is going to be there in this bill. So these are the important updates I would like to provide. I'm eagerly waiting for the visa bulletin to come in for the month of April, as we expect that the days are going to move forward for the EB2 category. Final action dates for the EB2 category is going to move forward, but not much for the EB3 category also for the month of April. But how forward it's going to move, we need to wait and see once the visa bulletin is published. And these are the very important updates I would like to discuss with. And one more update I would like to mention is that today morning I read some blog article written by some other lawyer, and as per them, And also it's true that the facts, but then the as per the facts presented or the data presented by the USCIS that have been adjudicated in the fiscal, that they adjudicated for the green cards in the fiscal year 2022 first quarter, that is ending December 31st, 2021, not promising. I mean, what I mean is that they did not adjudicate that many cases. So if they go like that in the same speed or same manner, it's likely that this year also USS may waste many immigrant visas without using them and allocating them for the green cards. And many people might suffer not getting green cards because of that. So hopefully that will be improved. Hopefully USS will improve it. But with the data what presented in that particular blog or from the USA's website, it is not that promising. That's all I can say.
Right. Right. So, thank you for all the important updates you've given us, Bhanu Garu. So, moving on, USCIS requires for the employers to attest that they have a bona fide job offer and did not collide with other employers to for duplicate registrations. What does this mean? And this is regarding this year's H1B cap registrations. So, what does this mean? Is that going to be a problem, or like, do you want to explain how it goes?
See, for the H1B registrations or H1B cap filings, there's always a restriction not to do a duplicate filing for an individual from the same employer, and now because of so many excessive filings happened last year, USS believed that employers might trying to game the H1B lottery system, the cap registration system, and trying to do multiple registrations for the same employee by colliding with other employer, and they do not actually have any bona fide job offer. What do you mean by bona fide job offer? Means the employer actually offering a job in good faith for the employee, saying that they would like to hire that employee in that position for which they intend to hire on H1B visa. Okay, so they need to have that. They need to make a good faith offer to the employee, and then submit a registration to the USCIS. That's what they're attesting to the fact. That is actually a requirement for any registration, but now they're wanted to put that in the paper also under the penalty of perjury, so that if they find any flagrant violations of those regulations, and they can make them subject liable individually also, not only canceling the registration, but also making them individual liable. But in reality, if you look into it, employee has a right to choose any employer they would like to work with. USCIS or any employer cannot restrict any employee saying that if you want H1B, you can only work with this particular employer. They cannot say that. That's against the, I think it's a very wrong stretch, but it comes under their constitutional right for the right to movement, right to travel. And that will be actually restrained by actually forcing the employee to work for one particular employer, either by the USCIS or by the employer or by any other agency. So as an employee, if I have an opportunity with multiple companies, and if the multiple companies would like to register for me, it is absolutely okay. But if I am the employer, and if I'm colliding with employer B, to make sure that my employee gets registered twice, because I want to take advantage of the system, I don't want my employee to lose the H1B lottery so that he won't be able to work or anything like that. That is actually the one which is restricted in this particular, not restricted, that is the one which is actually stated in this attestation, saying that you're not doing that. If you do that, then you may be subject to the cancellation or void of the particular registration because they're considered duplicate registrations, and also if the violations are so flagrant, then probably they may hold you liable subject to any visa abuse or anything like that, whatever the actions they can take and everything. So that is what this attestation is actually stating. So don't get confused. It's to the employer, not to the employee. If an employee wants to go and seek multiple opportunities and able to get the registrations done through multiple employers, as long as they have a bona fide job offers for you, then you are absolutely fine as an employee. As an employer, you also, if you have a bona fide job offer, yes, you can register for any employee. you're just attesting to the fact to that. Even if you don't attest to the fact to that, in reality, that is what you're doing, but you're not stating that in the penalty of perjury at that time, but now you are. That's all it is.
Right. So, Bhanu, while I agree that employees wanting to choose their employers is a basic constitutional right, I think duplication is a serious issue now. And that said, while employees might feel that while employees might feel employers are doing this to increase their chances of getting the visa or getting through to the process and registrations, now it is subjected to dire consequences by the USCIS, according to what you just said. But what I'm trying to ask is, how can employees protect themselves from employers who are trying to take advantage of the situation? There might be some employees who are innocent to something like this happening. How can one protect themselves, or can there be any sort of steps that an employee can take from duplication happening?
The employee can, I mean, what can employee can do if employer does the duplication, right? Because employer supposed to notify the employee where they're registering and everything for the employee, right? So that is something which we can't control. The whole issue is the employees, if they want to do multiple registrations with multiple employers, it is absolutely okay, as I said, as long as they have a job offer, bona fide job offer, that in good faith they intend to hire the individual in the position offered once the H-1B is approved. Okay, you cannot hire somebody, or somebody cannot work for you until the H-1B is approved. So what you can do is just make an offer of employment to them, telling that you intend to hire them in that position based upon the nature of your business and based upon the requirements that you're getting in your business. That's what the employer is doing. As long as the employer does that to the employee, I think that employee can actually trust that employer is doing the right way and proper way the registrations, so that those registrations don't get void unnecessarily or cancelled unnecessarily for any errors or any duplicate registrations. And if so, there is no dire consequences for the employee or really to an employer, as long as employer is actually believes and does the registration in good faith, saying that they do have a bona fide job offer and the requirement for the individual based upon the nature of their industry or nature of their business. That's all it is.
I'm sorry, I'm just trying to get something right here, and this will be my last clarification on this question. Does that mean that as long as an employee has a bona fide job offer, you're allowed to file multiple times for different employers? Just wanting that clear.
I'll give you one small example, Dharni. Okay, let's assume that I have a job offer from Microsoft, because I'm using these big company names because it's easy for people to understand.
Right.
Okay. I have a job offer from Microsoft, and at the same time, I've been offered a job from Amazon and also from some other company, which is a multinational corporation like a TCS, right? Tata.
Right.
And so all these three companies are offering me a job, and all these three companies telling me that they would like to hire me and they would like to sponsor H-1B for me. If required, they will go through the lottery process for me and get those things done. Those three companies have a bona fide job offers for me. And if those three companies want to do the registration for me, I can say, that's well and good. Three of you please do the registration for me. Whichever case gets selected, I would love to join that company. And that company can proceed filing an H-1B petition for me.
Yeah, now I think that point is
absolutely
clear.
Legal.
So, Bhanu Garu, we were talking about the H-1B cap registrations. And my next question is, will the employers have any issue if the employee has registered through multiple employers to seek an opportunity to be selected in lottery? Yes, I know we have been discussing just about this before the break. So do you think the employers should have any problem?
No, employers should not have any problem, because employers, as I said, if they have a bona fide job offer, they are registering for him. The same thing with every employer. See, I would love to have the very talented person whom I think will bring value to my organization, right? If I'm hiring somebody in my organization as an attorney or as a paralegal to do or to supplement or to assist my work which I'm doing, I will look into the person who can actually bring a value to that, right? How do you value an individual varies depending upon the need and the necessity of your business, right? And so if I value an individual X, that if that individual X is very valuable for me to bring him on board as a market research analyst or as an attorney or as a paralegal in my firm, I would definitely pursue him and I would give him an offer. I will entice him how better for him to come and join my company, to come and join my firm, to work for me. Same thing with other employer too. If he's well qualified, some other law firm or some other company which is in the needs of the same or similar services or about his ability, they will try to persuade him. They will try to recruit him. They will try to hire him. So in that way, they do the registrations for their company. I do my registration for my company because I do not want to lose this individual. USS cannot tell me that I can't do that, or anybody else. So in that way, employer, if you do that, and if the employee goes and does a multiple registration with multiple employees, because if the employer has a choice, I cannot tell employee that you cannot pursue other opportunity because I'm interested in you and hiring you, right? In that way, it happens. So because of that, employers should not have any issue if the employee goes and does the multiple registrations with multiple employers, as long as that employee believes that he has a bona fide job offer from those employers. That's all.
Right. So, Bhanukar, what do you think of interfiling of I-485 from one immigrant petition to another?
It's a very important tool or a procedure, discretionary procedure laid down by the USCIS for the individuals for the convenience purposes, right? Reason is see, many times what happens is people try to immigrate into this country in different manners, right? Like a family-based immigration, employment-based immigration, and sometimes, in fact, some people will be working for one employer to other employer. They move to one employer to other employer, and those employers will be filing different immigrant petitions for them. So he has an opportunity to utilize, just like CAP, he has an opportunity to utilize those green cards and join those companies and work permanently for them once they get their green card, right? So interfiling is a very good tool for the individuals to utilize, especially if their final action dates are current in the preferred category upon which their immigrant petition is actually pending, whether it's a family-based or it's an employment-based. In employment-based, in EB1, EB2, EB3 category. If it's a family-based, it's the immediate relative or as a spouse and children of permanent resident, or the unmarried children of the U.S. citizens, or unmarried children of the permanent residents, or married children of the U.S. citizens, or brothers and sisters of the U.S. citizens. These are the categories in a family-based where you can do the immigrant visa petitions, and at the same time, at the employment-based category also. So my thing is, as I said, if the individual has a final act, let's assume that there are people waiting in line, especially for the individuals who are in India, who are on H-1B visa or L-1 visa in this country, working for several years, like tens of years in this country, still waiting to get their GC because priority dates were not available for them. So they would have moved to different employers on H-1B visa at the time, and different employers might have sponsored them green cards. It's just a small example I'm trying to explain here to make you understand why this process is so useful, right? And one employer priority date is 2012 in EB2 category. Other employer priority date is, will be 2012, but it's an EB3 category because the priority date can be ported automatically once the other employer files his EB3 I-140 or EB2 I-140 or EB1 I-140. If that happens, and tomorrow the one person actually filed 485 adjustment of status application based upon one of those I-140s, and tomorrow or today or some other near future, the priority dates for the other employers I-140 became current, and if the other employer is willing to hire you, the interfiling is a process which becomes easy because you do not have to file one more set of 485. You can actually request the USCIS to consider the existing 485 application to tag along with the other employers I-140, and then ask them to adjudicate that case based upon that, because you do qualify for the position and the position is still available and the employer still intends to hire them permanently in the position which they offer him. So it's a very important tool. Interfiling is a very, very important tool, which is a discretionary tool, procedure provided by the USCIS just for the convenience of the individuals. So if any person doesn't utilize them when the USCIS is requesting them to utilize them, I mean, if tomorrow if the green card gets delayed, no one to be blamed but themselves.
Right, but is it preferable to file a new set of I-485, Bhanugaru?
It depends, right? It depends. It's a matter of convenience, and it's a matter of psychological convenience for each and every individual. There is nothing wrong in filing second set of I-485, but when you have a multiple I-485s, then obviously USCIS has to go through them and see basically why. Sometimes can think why this individual filed multiple 485s, and they have to combine and consolidate those files also before adjudicating your green card. It's not a bad choice. I've done so many of them in the past. It's not a bad choice. It's a matter of convenience for the individuals. But right now, because the USCIS actually suggested everyone to utilize the visa numbers available, especially for the Indian nationals. Visa numbers are available in EB2 and EB1 preference category, and the number of applications pending in that category was very few. They actually advised through their website that if anybody has I-140 pending in EB3, and if they have a priority current in EB2 category, and if they would like to utilize that EB2 I-140, just make the request for the interfiling, and we will basically consider your request and adjudicate your case as early as possible so that you can get a green card by September 2022. So because of the USCIS advice right now, as per current scenario, I would advise try to do interfiling. Otherwise, yes, there's nothing wrong in doing doing one more filing of I-485 if you would like to.
Right. So I think moving on to the next question, this is a question I'm sure a lot of people are waiting to be addressed. So are there any recent developments in the visa, processings at the US consulates in India?
Yes, we discussed one about the H4 visa holders, about the familial issues, right?
Right.
In the past show. Now we are going to discuss the other changes that have been implemented with the Dropbox eligibility, which have been recently changed in December at the Indian consulates, is especially for H-1B visas. People who are applying for H-1B visas, that they're now again requiring, especially if you're an employee of any consulting company and you're going to provide services to the third-party company like end client or vendor or anybody, then again, the Department of State is asking them to provide client letter, agreements, project documents, and all other itinerary and all other information to adjudicate visas. And if you don't provide them, they're issuing 221Gs in many cases recently. It's a recent development by the Department of State. So it's again, maybe it may be subject to the litigation. Probably somebody will file a lawsuit again and see what happens with that lawsuit and everything. But until then, you have no option if you want to get a visa, but to comply with what the consulates are asking for you for the H-1B visa issuance. We have seen several cases for which they're asking for the client letters and other things. In few cases, we did respond to them, explaining the facts that USCIS does not require them anymore because those memos and those policies have been considered ultra-virus and they've been cancelled and rescinded, and accordingly, they should adjudicate the visa based upon the preponderance of this, under the preponderance of the evidence standard, whatever the minimal information they provide you, if they believe that information is enough for them to believe that they have a bona fide job offer on H-1B visa petition, an employer is genuine and bona fide.
Right.
So that's why, that's only the option right now. So we are telling people right now, whoever is going to the consulate, to carry all the documents that are needed to adjudicate visas, which was happening prior to 2020 anyway. And we are telling them again to do the same thing. So that is one change, a very drastic change in the visa processing for H-1B visa processing at the consulates.
Right, so I hope it only gets better from here. And with that, Bhanu Garu, we
Yeah.
come towards the end of our session here. So before we go away, can you share a small immigration message for our viewers? Anything, any solution or any tips you'd like to give them?
Uh, very difficult to say. That's a very difficult question, actually, Tarini.
It could be just a
I do not
tiny
know where to
message
start.
about anything, just a tiny one.
I would tell them, dream. American dream is something which still probably the best thing which one human being can dream of. So if you have an opportunity to work in US, or if you have an opportunity to prove yourself, the America gives you the best opportunity, you know?
Right.
So never lose your dream to seek your opportunity in America. That's all I can tell. So it's
I
not
think-
that because I'm a lawyer
Yeah.
who practices in American immigration, but in general, still American dream is the best.
So I think that was a beautiful way to end this, and thank you for being on the show, Bhanu Garu, for the insightful messages and the information that you share with us and our viewers. You're watching Sakshi Live, and this is Torani. Thank you.